Creating a cooperative negotiation atmosphere early in the life of a dispute is a key to effective guided choice dispute resolution. There's many reasons to focus on process. In other words, procedural issues surrounding how the mediation will be conducted first. But one of them is that procedural issues are typically not controversial. They're typically not contentious. And so addressing them first, in other words, not talking about the merits of the dispute, but rather focusing on how will the parties be working together, laying out a process for the mediation that is going to happen over the next weeks. Addressing that first is something that can spark cooperative behavior, because allowing disputing parties to understand and also to help shape the process, it's empowering. If they feel that they can shape the process, they feel like they can guide it in a direction that will tend to serve their best interests. And one of the key things to understand about mediation is that parties can speak to a mediator, which is sometimes called a neutral, on a confidential basis. There's a thing as mediation confidentiality. And while there are ways that mediation confidentiality can be punctured or blown, at least theoretically, most people are going to be able to have discussions with their mediator on a confidential basis. And so starting with confidential discussions with the mediator and one party and the mediator and the other parties, at least theoretically, is something that can encourage lawyers and their clients to have open and earnest dialogues with the neutral. It avoids the danger that they may fear that their adversaries will gain some advantage because of the disclosures that they're making to the mediator, right? At least in theory, and it's certainly been my practice 100% of the time in the many mediations I've handled, that what I've said to the mediator has been kept confidential unless I've wanted it to be shared with the other side. And so if you start by setting out a good process, you can start the mediation off with an area of immediate and mutual interest of the parties. Everyone is interested in reducing the cost and the length of the dispute. Everyone is interested in retaining more control over the process and thus the outcome. And so the guided choice neutral can empower the disputing parties to build upon these mutual goals and establish mutual objectives, whether they're budgets or deadlines or certain kinds of information that need to be shared, and seek to have a mutually agreed upon and a rational approach to problem solving, developing solution-centric, goal-oriented methodologies of working together as part of this negotiation process that will play out eventually in order to achieve that early cost-efficient dispute resolution, which is so important to so many of our clients in the design and construction industry. And they could do this all while maintaining a healthy and constructive and cooperative relationship with one another by, again, focusing on process issues first. For example, let's try to understand how we might resolve disagreements before any particular disagreement arises, before people really get dug in on their positions about liability or damages or what one expert witness has to say or the other, or many other more petty things that might derail a mediation. Let's have a dialogue about the process of how we might agree to resolve these disagreements, because people are much less emotional when they're talking about these issues before any actual impasse or any actual quarrel emerges. Because again, where I think mediation tends to go wrong, and while I love mediation, I have been involved in a lot of really bad ones. One of the reasons why I think the traditional mediation tends to not achieve a settlement, or may tend to rub people the wrong way, is that I think that mediators too quickly pick a mediation date, right? They view mediation as an event when everybody is going to get together and exchange settlement offers. And I think that one of the goals of guided choice dispute resolution is avoiding this premature positional negotiation where parties don't have enough information to make a decision about whether it's in their best interest to settle or not. And here they are together. forced to start negotiations. And so they've got this premature positional negotiation where both parties, take very opposite ends of the spectrum. People get unhappy. They eat their Danish, they bang their fist on the table, and they leave unhappy, right? So you don't want to convene negotiations over things like settlement dollars early. And guided choice appreciates that agreeing to start to discuss with a neutral process issues is not necessarily an agreement for a party to ever sit down on a mediation day. A party's willingness to allow the neutral to investigate and to recommend a settlement process should not automatically be viewed as a commitment by the party to attend a classic mediation day. Deciding when and whether negotiations should take place is part of the initial phase of the guided choice dispute resolution process. It's all about devising a process to try to empower the parties to have control over how the dispute is going to be resolved, identifying ways where they may be able to come over the kind of impasse that you can anticipate at the beginning of the process, and achieve this early cost-efficient dispute resolution that we desire. So one of the core principles of guided choice dispute resolution is a commitment from the mediator and the parties to mediate the process issues first and get that nailed down before you ever get into negotiations around settlement dollars and similar things.